So the sentence in this case for murder in the first degree, kidnapping in the first degree, are each mandatory sentences of life in prison. That's the sentence the court will be imposing. While those sentences are mandatory, those are also the sentences that the court finds to be appropriate for these very violent, cruel, and completely senseless acts. Sir, your offenses are obviously devastating to Melody Hoffman's family, but they also undercut really the safety and feelings of security for the entire community. A sentence of life in prison with no possibility of parole is the appropriate sentence for these crimes, and they're necessary for the protection of the community. The maximum sentence for the offense of conspiracy to commit a forcible felony is a 10-year indeterminate prison term. While it's largely symbolic in this case, given the sentences of life in prison, for the other offenses, the court finds that the maximum sentence of 10-year indeterminate term is the appropriate sentence based on the level of planning involved and the fact that the forcible felony involved is a Class A felony. So at this time, the court adjudicates defendant to be guilty of the offense of murder in the first degree in violation of Iowa Code Sections 707.1 and 707.21b. And as a sanction for this offense, a defendant is committed to the custody of the director of the Iowa Department of Corrections for the rest of his life. The court further adjudicates defendant to be guilty of the offense of kidnapping in the first degree in violation of Iowa Code Sections 710.1 and 710.2. And as a sanction for this offense, defendant is committed to the custody of the director of the Iowa Department of Corrections for the rest of his life. As to each of these offenses, the defendant shall not be released on parole unless the governor later commutes the sentence to a term of years. The court further adjudicates defendant to be guilty of the offense of conspiracy to commit a forcible felony in violation of Iowa Code Sections 706.1b and 706.31. And as a sanction for this offense, defendant is committed to the custody of the director of the Department of Corrections for an indeterminate term not to exceed 10 years in order to pay a fine in the amount of $1,370. Defendant is given credit for all qualifying time previously served on this offense, and the terms of incarceration as to this offense only may be reduced because of good time work credits and program credits, and defendant may be eligible for parole before sentence is discharged. The sentences shall run concurrently to each other. Temporary custody is placed with the sheriff pending transfer to the DOC. Pursuant to Section 910.3b, defendant shall pay restitution in the amount of $150,000 to the estate of Melody Hoffman if an estate exists, and if no estate exists, to Melody Hoffman's heirs at law. Is there any other pecuniary damages being claimed?
Your Honor, there's a crime of assistance petition in there, so you know that, which I can file this on. $709.
And is there any objection to that claim, Ms. Eimerman? So the court will order that as provided in the statement of pecuniary damages on file. Defendants are presumed under the law to have the ability to pay what we call Category B restitution. I do have before me the required application and financial affidavit filed by defendant on November 15th of this year, requesting a determination as to defendant's reasonable ability to pay those. Does the state have a position on that application?
Your Honor, no resistant finding. Just not being paid.
All right. Court does find that defendant does not have the ability to pay Category B restitution and waives the same. This determination does not have any effect on the order for Category A victim restitution, including the obligation to pay the $150,000 to the heirs of Melody Hoffman. Defendant shall submit a physical specimen for DNA profiling pursuant to Iowa Code Sections 81.2 and 901.58A sub A. Defendant's prior bail provisions are exonerated, no appeal bond is set. In determining the sentence, I've considered defendant's age and circumstances, the nature and circumstances of these offenses, and the fact that the sentences for murder first and kidnapping first are mandatory under Iowa law. I find that the sentences will offer the defendant the maximum opportunity for rehabilitation and provide for the protection of the community. Mr. Louisma, you have the right to appeal this case to the Iowa Supreme Court. If you're unable to pay the cost of an appeal, you have the right to apply to the court for appointment of counsel and for the furnishing of a transcript of the proceedings, all as provided in Iowa Code Chapter 814. In order to perfect an appeal, you must file a notice of appeal with the clerk of court here in Lynn County within 30 days from today's date. This is a jurisdictional requirement, which means that if you do not file your notice of appeal within 30 days, you will be forever giving up your right to appeal. Likewise, failure to comply with the other provisions of Iowa Code Chapter 814 could preclude you from pursuing your appeal. If you do appeal, you must cause to be served on or delivered to the Iowa Attorney General a copy of the notice of appeal. Is there anything that either counsel believes I've missed today?
No, Your Honor.
Ms. Eimerman?
Your Honor, just to follow up, I can't tell from looking at the docket entries. The court did order the state to submit its closing PowerPoint in some form as a court exhibit. I can't tell if that's been done or not. If it hasn't been done, could it be done before we close the record?
It was done, and I entered a separate exhibit management order on November 18th at 10:51 a.m. that included the state's PowerPoint on a flash drive and your PowerPoint that was submitted electronically.
Thank you. Well, I appreciate you confirming that.
All right. So with that, we'll close the record. Thank you all.